Andrew, welcome to Constituting America's Constitutional Chats podcast. We'd love for you to share some opening comments on the Fifth Amendment, and then we'll go to questions.
It is great to be here, an organization that I love dearly, that I support enthusiastically. And coming on today to talk about what I will say is my second favorite of all of the articles or the amendments in the Bill of Rights, second only to the Ninth Amendment, which is my favorite, the Fifth Amendment to the Constitution. And I think it's important by way of introduction, and for those of you who are uninitiated or just joining us here as we move towards the Bill of Rights Day coming up in December, to understand that the structure of the Constitution is essentially in two parts, 2.5 parts. That the body of the Constitution itself lays out the very specific powers of government, what the various branches of government are supposed to do, whereas the Bill of Rights itself represents further constraints on that power, right? Ours is a government of carefully enumerated powers. Rights are infinite, but the founders felt, and I think rightly so, that it was going to be necessary to underscore the protections of individual rights vis-a-vis that government power. The founders were highly skeptical and nervous about government power, especially when it comes to things like the prosecution of criminal activity, that the police powers of a government can be especially powerful, to use a term, and can be apt to be abused. And therefore, many of the amendments in the Bill of Rights themselves deal with these constraints on power and the underscoring of the rights that individuals have. Things like trial by jury, things like limitations against unwarranted searches and seizures. And we get to the Fifth Amendment, and the Fifth Amendment is really interesting because the Fifth Amendment deals with things that are related, as I go through the list, but sort of divided up into as well two separate camps. What do I mean by this? So we have essentially 5 basic components to the Fifth Amendment, weirdly enough, because it's the Fifth Amendment. The first one says that anyone accused of a major crime, what they call capital crimes in the Constitution, in the Bill of Rights, can only be held if there's been some kind of an indictment that has been returned by a grand jury, i.e. a group of average, everyday citizens gets together, they look at the facts that are being presented to them, then that person gets indicted, and then they can be held. Number 2, the concept of double jeopardy. You cannot be tried for the same offense twice. If the government doesn't get its act together and is able to prove a case against you, they can't arrest you a second time and charge you twice. Now and I apologize for this, I knew the UPS guy was going to show up right as I was doing this. So that's double jeopardy, and there are ways around that. The third is one of the things I know I'm going to focus on today, the right against self-incrimination. You cannot be compelled to testify against yourself in a legal proceeding, especially if it's something having to do with criminality. You cannot be forced to testify against yourself. Then, and this is where it gets to me, why I look at the Fifth as very important, and why it's one of my favorites, is the right of, guys, I apologize for this so much. I can't do anything about the dogs. Let me just plow through.
We can't hear anything.
No, don't worry.
Oh, you're not.
We can't
Don't worry.
Oh, you don't hear the dogs. Oh, that's great.
Right.
I'm sorry, guys. I have dogs barking here. So let me quickly go through this. So there are two aspects of due process. Due process has to do with both substantive and procedural due process. The idea that when you are dealing with the government and you have some kind of a government proceeding or government's making a decision about your life, that the process that first of all, there is a process accorded to you so that a decision can be made, and that government decisions are not arbitrary. And the process itself has to be fair and not prejudicial. So that's substantive due process and procedural due process. We can get into this in the Q&A. And finally, and where I've spent a great deal of my professional life dealing with, is the takings clause of the takings clause of the Fifth Amendment, which is this idea that we've given government the power to take private property from individuals for things like land for public buildings, land for schools, land for parks, etc., but the use of that taking, the property that's being taken, has to be for a legitimate public use, and then just compensation has to be paid. In fact, I would say there are three elements to any kind of a taking. The government has to give you due process, the opportunity for you to voice to the government why your property shouldn't be taken. The government has to demonstrate that that taking is for a legitimate public use, as opposed to it being taken for someone's private use. And we can get into this. And then just compensation has to be paid. The free market value of the property, what a willing buyer would pay to a willing seller. And all of these things are up for great debate today. You know, what are the confines of it? What does it really mean when we talk about the issues of self-incrimination? What are the limits therein? Does it apply in all cases? In terms of property rights, there are a number of cases before the Supreme Court this term which deal with issues surrounding property rights. Two cases that deal with government administrative law, but I think have takings aspects to them, and one actual really interesting takings case that posits whether or not there are additional exceptions to it. So that's the fifth in a nutshell. As I said, there are five separate aspects to it. I know we're going to spend a lot of time talking today about self-incrimination, but I'm happy to also talk about anything else, double jeopardy, but especially due process and the takings clause. And with that, Janine, I turn it over to you.
Yay. Well, thank you, Andrew Langer. We are just we're your biggest fan. You're a Constituting America fellow. You've just been instrumental as a mentor and a scholar for Constituting America. So thank you so much. It's good to see you. Can we do let's do a flashcard thing here. I think it'd be kind of cool to put this up to show this amendment to everybody.
Oh, good.
Right to jury trial when you're charged with a crime. Well, that comes from all those. I mean, you just have to watch history and on Netflix, and if you don't read history, which I highly recommend, you see all the people being drug off to be beheaded or put in a dungeon or things of that nature, and they never had a trial. So that's the genesis of this, has just been things that we don't even understand here, because we've had 200 some odd years and generations of never having to be beheaded, at least, you know what I mean, but without a trial. Talk about a little bit of the genesis of that, and then the fact that it's a jury trial, and and this is like flashcard version, because I want to go through all five of these. But where does it break it down in the Fifth Amendment about how many people are going to be on the jury trial and things on the jury and things of that nature?
Not to sort of quibble about this, but really, when we're talking about the in the Fifth Amendment, the concept of the juries here is really about grand juries, and the idea of for major crimes, that you know, it's just not up to one person or one small group of people within government to go out and decide to charge somebody. That in point of fact, it has to be the evidence has to be looked at in advance by a group of average citizens who are empaneled to do so, and they can go and they take a look at the evidence. Now, as we all know, like everything else, one of the great problems we have in America is that people are unaware of what their rights are, and that when you are faced with the power of government coming down on you, it becomes very difficult for you to assert those rights. And that really gets into things like double jeopardy and self-incrimination. We'll get into those in a second. But the point is that the founders recognized that because government has enormous power and can put so much pressure, and that prosecutors can put such pressure, that they created this grand jury system. And one of the problems, of course, we have today is that you know, we like to say that a good prosecutor, you know, working with a group of citizens who don't really know the law, and because a defense attorney does not have a chance to cross-examine during a grand jury's investigation, that a good prosecutor could indict a ham sandwich. That's the old line that's been used. So when you look at lots of different cases, you know, especially in high-profile cases, just because
Can I just interrupt, Andrew? I just want to interrupt for 2 seconds.
Yeah.
So I was looking, because we didn't have this up. I was looking at some definition on the internet, and it just said trial by jury. So now when I look at the actual Constitution, which I think is great that we put it up, it said, and I just want flashcard single sentence answers, right? Because I only have 6 more
Oh,
minutes
sure.
and
Sorry
I've got
about
to
that.
toss it over.
Okay.
No, that's okay. You and I could talk for hours, but
Yeah.
so I just want the students that are listening to really understand what this means. So my question for you is, obviously it's not, I guess it's the Fifth Amendment does not give us the right for a trial by jury. And is this just the government? The government cannot charge you for a crime without a grand jury. It doesn't give us the right to trial by jury in the Fifth Amendment. One sentence.
Trial by jury is elsewhere in the Bill of Rights. The Fifth Amendment deals with the issue of grand juries and grand jury indictments for
Okay.
major crimes.
Is this so? Is it the government? Is it the government coming after you? Is it only talking about the government coming after
Well, right,
you?
because when in any instance in which you're being charged criminality, it's always the government, whether it's the federal government or a state government, that's coming at you. It's the government that's coming
Well,
at you.
but it's not always in our minds. Like if someone's in 8th grade listening, it's not always. So your neighbor can sue you, and or you can be taken for
Right. So
a trial.
if your neighbor sues you, you're not going to be charged with a crime. So it's not a criminal thing. It'll be a civil thing.
Well, okay, I used the wrong thing. So let me just make this really
No worries.
simple. Grand jury is when the government, because there are other trials that are not just by the government, right? There are a lot of trials that are not with the government.
Let me be really clear here. So a grand jury is before the trial itself. A grand jury examines evidence that a prosecutor puts before them, and they make a decision as to whether or not someone should be arrested and then charged. It leads to what's called an indictment. An indictment is what someone is charged with. So
Okay,
then
with the government.
Yeah,
with the government.
Yes. So what happens is that a government prosecutor says, I think Joe Smith committed murder. He goes to a grand jury and says, here's my evidence of Joe Smith committing murder. The grand jury looks at the evidence and they say, okay, we're going to charge him with it. You can go after and charge him with murder, and they issue the indictment. The indictment gets issued. That's how it works. And then it goes to trial.
Okay,
eventually.
and we hear that word indictment all the time. They've been indicted by a grand jury. And I think you touched on this. I think something that's really interesting for everybody to understand, and you touched on it. And a grand jury is listening to facts only from the government's side.
Right.
So the defendant does not have a chance to defend themselves. And none of that has been heard when the grand jury is making their decision. It's just one side of the government saying, we think this needs to go further. And then the indictment is when the grand jury says, all right, take it further. But, a lot of times people are indicted and it's so detrimental, but really they haven't even had a fair trial yet.
And that's exactly it. And part of it is to protect, the defendant himself, so the defendant doesn't go forward and have to testify and sort of mount a defense yet. Though it's important that, in criminal procedures, that the prosecution really has to lay its cards on the table so that if the defense can mount its defense. But yes, that's exactly right. Just because somebody's indicted doesn't mean they're guilty. That's why the presumption of innocence is so important in our legal system.
Fabulously interesting. Okay. And a grand jury, where does it define how many people are in that jury or how they're picked?
So I believe it's not defined in the Constitution. It's still, 9 people, or no, it's a dozen people in a jury, in a grand jury. And usually it's defined in either the Federal Rules of Civil Procedure or at the state level itself.
Okay. So they don't ever say how many people in the Constitution.
No, they don't in that case. No.
And sometimes I guess people have a grand jury and they decide not to go forward.
Sure.
With it. We just don't ever hear about those.
Very rarely, right? Because grand juries and grand jury proceedings are usually done in secret. You're never supposed to know who's on the grand jury. In fact, in many cases, they don't want people to know that a grand jury's been impaneled, because they don't want to issue the indictments until they're absolutely certain that someone's been indicted.
And the defendant knows. Does the defendant know?
Sometimes the defendant knows, sometimes the defendant doesn't know. Right. If sometimes a prosecutor will let a defense team know that their client is the target of an investigation. Sometimes it's a surprise. When you look at the history, for instance, of mob trials, and a lot of those mob defendants are unaware that that there's been a grand jury impaneled to go after them. Major public figures as well.
Really interesting. Yeah. I can't see, because I'm not on Brady Bunch screen how much time I have left.
About a minute and a half.
Lacey's one. Minute and a half.
Yeah.
That's not a lot of, oh, what happened to the, oh, I was looking at the amendment again. Well, see, I was looking at the wrong thing again because I just saw I was in the wrong amendment, I guess, because it said trial by jury. So this is really
Sure.
interesting because I was not clear. Now everyone listening will be super clear. That's like it on tests. You learn more from your mistakes
Exactly.
than all the ones you get correct, right?
That's right.
So we now know that the Fifth Amendment talks about the grand jury indictment, whether to go forward. They're only listening to one side that the government's putting forth.
Yeah. Yeah. And then it gets into the issues of double jeopardy, self-incrimination. You can't incriminate yourself. You can't be compelled to testify against yourself. The issues of fairness in these procedures, due process, which is vitally important. And then we get into the takings clause about the taking of private property for public use.
Yes, I'm looking at that. I was just going to stick with one because that's all I have time for. If can you give us in the last 20 seconds here 5 examples of an indictment for a grand jury of those type of crimes or recent ones? Because I like to correlate this with the modern.
Well, right. I mean,
day
we've got
story.
this Sam Bankman-Fried trial that we've been talking about. That's super huge. We've got
So a grand jury had to indict him first.
100% a
Yes.
grand jury had to indict him. I mean, most of the major political trials that we're looking at, we go down those roads. Any of the trials of the police officers that are involved in so-called police brutality. I mean, all of these things, any of the major cases you're hearing that are felony cases, those are all going to have had grand jury indictments. When we're talking about misdemeanors, generally those don't have. Now, sometimes people will plead them down. I don't want to go down that rabbit hole, but for these major cases you're hearing about on the news, for the most part, they're going to have grand jury indictments coming after them.
Interesting. Okay. Thank you so much, Andrew Langer.
You're welcome.
Appreciate it.
All right. Yeah. Thank you so much for being on, as always. Always great to have you here.
Yeah.
So I wanted to concentrate a bit on the word compelled
Yeah.
because I just think that's an interesting word there. So could you be a bit more specific about what it means to be compelled to be a witness against himself? Like we've talked about, the government, you can plead the fifth and not testify. But
Right.
what about a plea deal? What about, saying, what if the government says, say possibly incriminating evidence, but we will give you a lesser charge, that sort of thing? What about witness intimidation from a third party, those sort of
All
scenarios?
of us, I mean, witness intimidation from a third party, that really has to, that has to do with, tampering, and that's a whole separate issue. But let's talk about those other things because they are really, really important issues. And what Tova's talking about is, it is enshrined in the Constitution, this idea that you cannot be forced to give testimony against yourself, that you cannot, you don't have to be, you can't be forced to admit that you did something wrong, that in our legal system, you are innocent until you're proven guilty, and it is up to the government to prove their case. You don't have to do the government's work for you. And some of this gets into what we've all heard about the Miranda rights, right? This idea that when you're arrested, you are told that you have the right to remain silent. That is a restatement of the Fifth Amendment's protection against self-incrimination. Now, what it means in a general sense, and in the sense of sort of trial law, and let me be really clear, I'm not a trial lawyer. I've worked with some very talented trial lawyers over the years. The idea is that that if you decide to not testify, right? A, you decide not to take a stand on your own behalf, or B, you decide to not cooperate with the government in their investigation, that cannot be used against you in the later proceeding, or at least it shouldn't be used against you in the later proceeding. Juries are instructed that if you did not testify or that you pled the fifth because you didn't want to incriminate yourself, that they're supposed to ignore that as a condition. Now, whether or not they do is a whole another question entirely. What Tova brings up is the issue of compulsion and just what that means, and pressure that can be put on people. Now, there is a great deal of discussion as to whether or not the overcharging of individuals as a way of forcing them to cooperate with an investigation, whether or not that could be a violation of the Fifth Amendment. The The law is not very clear in that regard. What that means is, the government has you on, I'll give you a really good example. In an endangered species case, somebody was accused of importing, it's a true story, accused of importing undersized lobster tails in violation of something called the Lacey Act. But they didn't just charge him with violation of the Lacey Act. They charged him with violation of, it was wire fraud, it was smuggling, it was a bunch of different things that they added onto it as a way of forcing the accused to cooperate. And that's a very common tactic nowadays. Again, it gets into the issues of abuses of power. But I want to be clear about some things, because there are limitations. I'll be real quick about this. There are limitations to the issues of self-incrimination. For instance, physical evidence. You can be compelled to give your DNA. If you're charged with murder or some other violent crime or something else, you can be charged with giving up your DNA. If you're required to keep records as a part of your business, tax records, other kinds of records, you cannot refuse to give up those records and invoke your Fifth Amendment right to self-incrimination, right against self-incrimination. You have to give up those records. Then, I'm sorry, I'm going through my notes. If prosecutors have offered you immunity, Tova touched on this very briefly. If the prosecutors say, we're not going to prosecute you for anything else, but you have to give up the goods here, then you can't invoke your Fifth Amendment right against self-incrimination from then on. If you decide to take the stand in your own defense, this is called waiver by testimony. So let's say we could talk, Kathy asked me to talk about a little bit about Sam Bankman-Fried. Once Sam Bankman-Fried decides to get up on the stand and testify in his own defense, he cannot get on the stand and then invoke his Fifth Amendment right against self-incrimination, because the prosecutors, listen, there are many things in which they make it very, very fair for defendants. But if a defendant gets on the stand and a prosecutor is hampered by cross-examination by a defendant invoking his right against self-incrimination, it creates huge problems. So it's called waiver by testimony. Public employees, such as police officers or government officials, they can be compelled to testify about things that go on their job by virtue of the fact that they're government employees. And then there was one more that I missed here, which is, the foregone conclusion doctrine. If government has evidence in its possession and it presents a defendant with that evidence, and they've already reached a conclusion based upon that evidence, and it merely needs the person to authenticate them, is this so-and-so's signature on a document? Is this a plain ticket with your name on it? Then that you can't invoke your Fifth Amendment right, because it's there right in front of you. Now you can go and defend yourself in other ways. So those are the limits here. But the idea is, again, that it is up to, in our system, it is always left to the prosecutor to have to prove their case. It's up to the defendant and the defense team to defend themselves.
Well, thank you very much. And then I wanted to concentrate for my next question about another part of the amendment, which is the, nor shall private property be taken for public use without just compensation. I wanted to ask about at a time when now so much of property is intellectual property or digital assets or virtual property, how is it the same process of eminent domain if the government wanted to, for instance, seize intellectual property or seize virtual property for a public good? And are there any cases where that's been invoked?
Well, sure. I mean, the answer to the first part is yes, because again, property is property is property is property. And just because it may not have a corporeal existence doesn't mean that it doesn't have some value. I mean, essentially, there are a lot of different ways to look at property, but if it has some kind of value or a net worth to you, and it is taken by the government, and again, we can get into there's the whole other issue of civil asset forfeiture, which is actually, I'll get to that in a second. If government takes it for public use, then just compensation is owed. And that's, so now I don't know if there are any cases about virtual property. I'm sure that there must be, probably in the asset forfeiture side of things. But in terms of intellectual property right, this was actually a huge debate during the COVID-19 era, in which, whether or not the government could use eminent domain to essentially seize the intellectual property behind vaccines. And eventually there were negotiations that were made between the vaccine manufacturers and the government so that they held on to their intellectual property, but the government paid them for their use. There are exceptions, and this drives me up the wall, but when the state exercises its police power, it can seize property without paying just compensation. This is a little bit different than the public use issue. And there are, I believe, a couple of civil asset forfeiture cases up before the high court now, i.e. you are accused of committing a crime, therefore the government has the power to take your private property from you as an unjust gain. And like everything else, when you give government power to do something like this, that power can be abused. And we have essentially incentivized the power of both the federal government and state and local governments to seize private property under the police power. And they have done it. And a lot of people have gotten hurt by this. That extends from a late 19th century case called Mugler or Mugler, depending on who you talk to in terms of the pronunciation, in which the state shut down or the state enacted prohibition laws. A brewery got shut down. The brewers sued the state of Kansas, and the Supreme Court said, no, under the police power, you don't get compensation when the government shuts down your business. I think if that were relitigated today, I think that might reach a different outcome. We now are in an era where the court takes all kinds of private property rights claims much more seriously. And I'm sorry, I know I went a little bit over time there. I apologize.
No, that's great. Thank you so much. And
Welcome.
I'll pass to Jewel and Jordan.
So first of all, thinking about court, when we think about going to trial and having to say if you're having to testify and you're swearing to tell the truth, oftentimes when you first hear about pleading the fifth, it's almost a little confusing. Can you kind of tell us possibly where that came from our founding fathers and like Magna Carta, or where did that idea of protecting people from having to testify against themselves come from? Since we're talking about, you're in court, you're in trial, you have to tell the truth. That could include testifying against yourself.
Right. Actually, it's funny. I'm not actually certain where the self-incrimination portions, where they're rooted in common law. I dare say that it may be a fairly recent invention. And by recent, I mean, sometime recently before the late 18th century. But it became very apparent to the founders, given the abuses of the English legal system vis-a-vis the colonists, given the enormous power that the government has in terms of dealing with these things, that a citizen should not be forced to testify against themselves. That again, if we put the presumption of innocence on the defendant and we make it up to the prosecution to prove their case beyond a reasonable doubt. Oh, and I think it's also important to recognize that there's a difference because Janine raised the issue of civil versus criminal. I'll get to that in a second. That you shouldn't have to testify against yourself. The government has to prove that case, and that it can't be held against you in the eyes of a jury. Now that's true for criminal cases. But if you are sued civilly by the government and you plead the fifth, you invoke your right against self-incrimination in a civil case, a judge can instruct a jury in that kind of a case to say that, they can use that as some kind of an indication that the defendant or the respondent believe, is an indication of their guilt or their culpability. But again, the standards are all different here. But yeah, the idea, the founders were very big on this idea of making sure that the rights of defendants were being protected, because government power can so easily be abused. And I think, frankly, they may have also seen down the road the ease by which a good prosecutor could manipulate a grand jury to return an indictment, and understanding that down the road, a defendant would be able to, or would have their literal day in court to defend themselves. so that could they so choose, or that their defense team could mount a defense on their behalf should they choose to not testify.
Very interesting when you consider that other countries and other court systems would not have that protection against against not testifying against yourself, and it's worth thinking about that, our founders, why they would have put that in. So thank you for that answer.
Yeah.
Also, the next thing I want to talk about was the taking. Do you think that if our founders were looking at, obviously ignore every other million things that they would be looking at, if they were looking at our modern era, if they would have put in a greater protection or a tribunal of some sort where it was just much harder for the government to take your property for any purpose?
Well, I think that they would have been, well, it's funny because they wanted to keep the structure of the Bill of Rights as airy as possible. In order, there was sort of a strength in the elegance of the writing there, and they didn't want to weigh it down with a lot of free interpretations. I think that they were hoping that we would stick to sort of the interpretations of the time, or that we would be a little bit more detailed via legislation down the road to meet with the changing of the times. I don't think that they would have envisioned an environment in which, let's say, land could be taken under the Fifth Amendment's takings clause. Someone's house could be taken, and then that land passed to another private entity to build a parking lot. I mean, setting aside the fact they wouldn't know what a parking lot was, as was the case in the Kelo case of 2005, I think it was. That was a case in which a woman in New London, Connecticut, had her home taken so that Pfizer could build a parking lot for their new corporate headquarters. Ultimately, they didn't build their headquarters there, but set that aside. That's, but they should have left it, and I think they would have wanted to leave it to future generations to go and define what public use meant. I don't think they could have envisioned 100 years or so of the erosion of that phrase. Plus, the other part of this is I don't think that they would have envisioned the erosion of the concept of due process, right? Because the two go hand in hand, right? The first part of the Fifth Amendment is all about criminal things, and they all go together. The indictment process, double jeopardy, self-incrimination, and due process all go hand in hand. The Fifth Amendment's a little different, but the Takings Clause is a little different, and the Takings Clause connects to the rest of the Fifth Amendment via the Due Process Clause, right? There are three things that need to happen when private property is taken. It has to be for a legitimate public use. Due process has to be given to the property owner, and just compensation has to be paid. And one of the great problems we have in America today is that the processes by which people go and defend or oppose their property being taken is watered down, and we'd have neither substantive nor procedural due process. Again, I look at a case, I'll be real quick about this. A case out of Monterey, California. I don't know how many of you have been to Monterey, California. But a guy buys the last piece of oceanfront property, buildable oceanfront property. Pacific Grove, California is really where it was. And it was land that was zoned for residential. When he bought it, he was allowed to build a residence on it, but the city of Pacific Grove didn't want him to build a house on that land. And what they wanted to do is they wanted to try to raise the money to buy the land outright from him, which is they have their powers to do that. But they couldn't raise the money. The rest of the city didn't want to do this. And so they kept this guy in a due process procedural limbo for years, hoping that he would just give up. And again, it gets into both the procedural and substantive aspects of it, because number one, they just kept him in a hamster wheel of forms and forms and forms. That gets to the procedural side of it, but they also had a predetermined conclusion. They were not going to let him build on his land. So substantively, his due process rights were violated. And thankfully, these things are greater defined in the United States Code. I believe it's 42 USC 1983 deals with due process issues. That's what the founders wanted. They wanted those things sort of left to the legislature. I think, and a number of legislatures have done this since the Kelo decision, they have defined just what public use means, so that you can't take private land from one property owner with the idea of giving it to another property owner down the road. And if anybody wants to, I could talk about what the Kelo case hinged on, but we don't have to do that right now.
That's very interesting. Could you give me a little history of why double jeopardy was introduced in the Fifth Amendment? Why was
Well, right.
why-
I mean, the idea, again, getting down to this idea of government power and government power being abused, the founders recognized that if you had an individual that wasn't liked by a prosecutor or was somehow a pariah in his community, a good prosecutor could keep them bound up for years in constantly being prosecuted for the same case, not just twice, but 3 times, 4 times, 5 times. And so the idea is that a prosecutor gets one shot at this. You bring your case, you give it your best shot, and if you lose, then you lose, and that's it. The problem we now have in America today is that we have situations in which someone who may get prosecuted in federal court, and the prosecutors lose in federal court, they might get indicted at the state level, or vice versa, or they might get indicted for a different crime that may be related, but not the same thing, but yet they're still kept in the same kind of legal limbo. That's a huge issue. And I won't get political, and I won't tell you the details, but there was a circumstance in which a father in Pennsylvania, he was going to get charged with assault in a particular political situation. The state prosecutor, the local prosecutor, dropped the case, and the federal government stepped in there and intervened and turned around and prosecuted the guy, and they wound up losing there as well. But the bottom line here is it shouldn't have happened. You know, again, he should not have been pursued twice for the same offense. This is a huge issue.
Thank you. And we are just at time, and I'll pass to Kathy for some audience questions.
Well, thank you, Jewel and Jorn and Tova and Janine. Those are great questions. And Andrew, it's just so great to have you with us. Before we go to the audience questions, we want to recognize the students in our audience today and teachers. We want to give a shout out to Hope Mucklow, who has a homeschool student with her today watching. And Hope is also the author of Rojo the Red Panda, and she's donated that to our auction. So thank you, Hope. We also have Alan Amadal with Albany Senior High School and 27 students watching, Christina Allen with homeschool students, and Cami Waynos with homeschool students. So welcome to all of our teachers and students who are watching. If you're watching and we didn't give you a shout out, let us know in the Q&A, and we'll be sure and do that. We also want to thank our listeners, and Las Vegas's KKVV 1060 on the AM dial. Las Vegas's KKVV airs these podcasts Monday nights at 6 p.m. Pacific. So thank you, KKVV, and all those who listen to us in Las Vegas. Now, Andrew, we've got some great audience questions, and I think we'll start with Frederick, who asked about a Supreme Court ruling that was a fairly recent ruling. I believe it was in May 2023, and we had actually looked at this when we were getting ready for the podcast, this Tyler versus Hennepin County, that said that the Supreme Court, it was a 9-0 decision, by the way, which is a unanimous decision by the Supreme Court, that said that I believe if the Supreme Court takes property, that it cannot also take back taxes at the same time.
Oh yeah. Oh no. This is a great case.
Okay.
So in this case, it's actually an interesting correction of a case that frustrated me greatly about almost 20 years ago with Justice Roberts deciding. So this is a case in which the locality had taken Mrs. Tyler's condominium, I think it was, for failure to pay back taxes, and they turned around and they sold it at auction, and they kept the profit from the auction. And so Mrs. Tyler, she sued because she said, well, wait a minute, you can't turn around and make a profit on my property if you're going to sell it. You get the back taxes that you're owed. And I get to keep whatever else is out there. I mean, I suppose I could have done this myself. And the Supreme Court, I mean, again, this is one of those, actually, it's not so rare. The Supreme Court's had a lot of really good 9-0 decisions in the last few years on these kinds of cases. And so the idea is there's a property right inherent in the equity value that is, it's the direct value, the assessed value, but the sort of the invested value your property. And so just because you didn't sell it doesn't mean that the state gets to keep everything. That was a really great decision this past year. And I say it corrects an historic ill because about 20 years ago, 05, 06, I think it was, in a case called Jones v. Flowers, Justice Roberts, writing for the High Court, made it easier for local governments and state governments to take private property if back taxes were owed. It had to do with notice. It was a whole thing. I was not very happy with Chief Justice Roberts on that day. And I think this is a step towards redemption in that regard.
Well, thank you.
Yeah.
And you may have already asked this, but Connie had emailed in this question, so I wanted to make sure that she felt like it got answered. Connie's asking if can you plead the fifth for part of the questions, or must you plead the fifth? Connie says from the get-go.
Until you take the stand. And so I think testifying on Capitol Hill is a different thing. I think if we're talking about criminal proceedings leading up to a trial, in terms of an investigation, you can answer parts of questions. You can you can plead the fifth on some and not plead the fifth on others. But if you do wind up taking the stand, then you can't answer some and not answer others. That's as I said, it's the issue of as I wrote it down, waiver by testimony. This issue of if you've stepped up there to say your piece, and there is an instance in which the prosecution has the power to cross-examine you, then you can't sort of step back there and frustrate their ability. This generally pertains, as I said, to criminal cases. It's less of an issue, or it's less clear when we're talking about testifying before other kinds of government investigatory bodies.
Well, thank you. And then we have two audience members, Robert and Lewis, who are both asking about asset forfeiture.
Yeah.
And Robert asks, how is asset forfeiture legal? For example, a truck driver by the name of Jerry Johnson had $40,000 in cash on his way to buy a new truck.
Right.
The local police apprehended him and seized the cash at Phoenix Airport.
Right. Well, that's the issue. That's the issue of the police power. And it gets back to this late 19th century case, Mugler versus Kansas, in which the state in which they're exercising their police powers, they don't have to pay compensation for it. They can seize these things. Now, as I said, there are this has been litigated greatly, and I urge folks, if you're interested in the civil asset forfeiture, look at the work of the Pacific Legal Foundation and the Institute for Justice, two fantastic nonprofit legal foundations in America that have way too much work, almost more work than they can handle, but they really are leading the way in terms of prosecuting these things. Pacific Legal Foundation has an unprecedented, I think it's a 17-1 record before the Supreme Court right now. And they've just I think they just argued this week another civil asset forfeiture case. But yeah, it comes under the police power, and somebody's got to step in and rein it in, because essentially what you're doing is we've given police departments and law enforcement agencies a profit motive for doing these things. I don't remember the guy's name. There's a really horrific case of a guy got stopped outside of Reno, Nevada. He was on his way to buy a house for his kids. He didn't trust banks. Who can blame him these days? And he got stopped, and the police officers knew that it had nothing to do with drugs. They knew, and yet they seized his cash anyway, because they knew that they would take a certain percentage. The feds would take a certain percentage. It's a real mess.
Well, thank you.
Yeah.
And then another question from Lewis: how is being able to be tried in both state and federal courts not double jeopardy? Right. And that's an important question, and one that has to be answered. The problem is that they are two different, right? This is the problem, right? Because one action can have many different crimes associated with it, and a federal crime is different than a state crime. And so, and there are different standards of evidence, different rules of procedure. And so no one has ruled on this idea of, if you're charged with X in state court,
and you're charged with Y in the federal court for the same activity, why is that not the same thing? Well, it's different because they're two different crimes. It's one of those areas in which the law has really fallen down and not kept pace with the realities of the modern world.
And Timothy also
and
asked.
hold on. Let me just real quick. I'm sorry. Let me just add. And part of the problem is that we have expanded the federal criminal law into areas that the founding fathers never thought the federal government was going to get involved in. That's the other part of the problem here. Sorry, go ahead.
Yeah, no, thank you. And I want to say Timothy also asked that question, and Timothy added on, what about being tried for the same event when new evidence is uncovered?
Well, so okay, so that's the issue, right? If you have been tried and you've been acquitted, if you've been accused of murder and you've been acquitted of that murder charge, even if new evidence comes up, it becomes very difficult for a prosecutor to go, well, first of all, they can't go and charge you for murder. But even if they could, it becomes very, very difficult down the road for something like this to happen. Again, we've really put an emphasis, and I think rightly so, on protecting the rights of criminal defendants in this country. So normally it happens the other way. It's all too frequent that the new evidence shows up and it exonerates someone, as opposed to signifies the guilt if they've already been demonstrated to be innocent. Anyway, so right, OJ can't be tried a second time at this point.
Well, thank you for clarifying that. And Mel asks, what can be done to correct overreach as far as the government using obstruction of justice to put people in jail or getting information? Mel says problems coming, let's see, evidence that they don't have against anyone to prosecution, which is overreaching its authority.
Well, right. So what he's talking about is this idea of using nebulous cases and tenuously defined things to intimidate people into cooperating or intimidating them into pleading guilty. And the only real answer to this, again, is legislation. This idea of trying to find a way to sort of limit the scope of a prosecution so that someone can't be overcharged. What I find really buoying is that both folks on both the left and the right recognize that there's something fundamentally wrong. I mean, take the political trials out of it for a minute. But on both sides of the aisle, there's a recognition that, just overloading a case with charges, especially charges that can be very much subjective, like an obstruction of justice charge, that's something that needs to be dealt with at a statutory level.
Thank you. And here's one near and dear to your heart, because I know that you are very concerned about regulatory issues.
Yeah.
Dwayne asks or states that a regulatory agency has determined that a community with 4 backup electric generators must service just a portion of their town with power during a power emergency. The remaining generated power must be sent to the main line. Does this go beyond the regulator's power? Are you familiar?
Well, it's actually really interesting, because that's part of what's at issue in a Supreme Court case, and I can't remember the parties' names. I'm having a brain freeze right now over just what kind of exactions can be made in terms of the permitting process in order to approve a permit in a town. How far can a municipality or any government agency go in forcing someone to give up various aspects of their property rights in order to get their permits approved? I think that in the end, that these are takings, and these are takings that must be compensated. It's one that hasn't quite been decided yet. Right. Again, just to take the fact set that the questioner is asking. So electricity, which is something that people pay for, and they pay for to get it set up, that is a property. There is a property interest in it. The government is forcing the taking of that property. They're forcing that taking of that property for a general public use. Therefore, to me, the Constitution is very clear that just compensation must be paid. Right. We have a system that is predicated, even especially in this amendment, on the fact that the government cannot use force to achieve a desired end. not without due process, and not without just compensation being paid.
Well, thank you. And I want to make sure we circle back to Jewel and Jorn and Tova and Janine just to see if anybody has any burning questions that we didn't get asked in the first round.
Yes, one thing. Do you know if there was any founding fathers who just argued completely against any takings of the federal government being able to force it even through due process?
Oh, you know something? I don't believe so. I think everybody recognized that at some point in time, especially back east, where lands were generally held in private hands, that in order for government to function at some point, they were going to need to take land for things like government buildings and roads and things of that nature, but that they had to pay due process just compensation. Real quick, 30 seconds on this, because to get back to the previous question real quick, there are two other cases that are up before the Supreme Court this term, having to do with the administrative state. But again, I think there are takings aspects to it. They're not being litigated here. Now, the question is, the government, that you have these fishing vessels, the government is forcing fishing companies to put government safety monitors on and fishing inspectors on these boats, and forcing the fishing companies to pay the salaries of those inspectors. Now, they're dealing with the interpretation of something called the Chevron doctrine, which we won't get into. But to me, I think that there's a takings aspect there. If someone's forcing you to take somebody onto your private property and interfere with your business, and then forcing you to pay for it, that to me is a regulatory taking right there.
Well, thank you. And we're right at the top of the hour. We want to thank all the audience members for being with us today and for your great questions. And thank you, Jewel and Jorn and Tova and Janine and Lacey. And thank you, especially Andrew. We could have probably gone another hour at least on this. So we really appreciate you being with us and all your great insights.
Always happy to be here. Thank you all very much.
So we just want to remind everybody
Thank you, Andrew.
Yeah.
Thank you, Janine.
And join us next week, Tuesday at 2. We're going to be talking about the Sixth Amendment. Thank y'all.